Hello and welcome to the Student Legal Services Lease Review Pre-Appointment Presentation. My name is Molly Hagerty and I'm the Managing Director of Student Legal Services. On behalf of all of us at SLS, we look forward to assisting you. Please note that this presentation is intended to relay the general information that we give in every lease review. It does not replace the specific legal advice you will receive in your lease review appointment. Before we get started, I want to introduce you to Student Legal Services. We are a nonprofit law office that Ohio State specifically chose to contract with to provide legal services to Ohio State students. In addition to me, there are 8 full-time licensed attorneys at SLS. SLS is a confidential resource and all of our staff is covered by attorney-client privilege. We cannot share your information unless you give us permission to do so. In addition to off-campus housing and landlord-tenant services, we assist thousands of Ohio State students per year with the legal issues they typically face, including those listed here and much more. If you are unsure whether SLS covers your issue, please visit our website, email, text, or call us. When you sign a lease, you are signing a legal contract between you, your roommates, and the landlord. We strongly encourage students not to rush into signing a lease. You should feel comfortable with the lease, the landlord, and the place you'll be living. If you're ready to sign, we are ready to provide you with valuable information and to be a resource for you as you move forward. We also want you to know that while the lease is a very specific and important document, it is not the only thing governing the relationship between you and your landlord. There is also a set of laws in Ohio called the Landlord-Tenant Act. Sometimes what your landlord puts in your lease contradicts the Landlord-Tenant Act, and so the landlord cannot enforce those provisions. If you're ever unsure whether your landlord is able to do something or charge you for something, that is a really good reason to schedule an appointment with Student Legal Services. What do you know about your landlord? Being an educated consumer means doing your research. To learn more about your landlord generally, you can review the Undergraduate Student Government's Renter's Guide online at offcampus.osu.edu. USG surveys students about their experiences with landlords, including how quickly landlords responded to maintenance requests, whether the landlord returned the security deposit, and more. You'll also want to check your lease carefully to note your landlord's name, address, telephone number, email address, and their property manager, if there is one. If you do not have your landlord's name or contact information, you should absolutely get that before you sign. Have you read through your lease completely? Are there any sections you have questions about? Be sure to highlight those so you can talk to the SLS attorney during your appointment. Do you want the landlord to change anything in the lease? If so, make notes about that and discuss with your SLS attorney. Any changes to the lease must be put in writing and signed by the landlord in order to be enforceable against the landlord. Has the landlord made any promises to you about the property that are not in the lease? If so, you must have them put these changes in writing, preferably in the lease itself or in an addendum. What happens if the landlord doesn't fulfill the promises? You want the written agreement to include that information as well. After the lease is signed, you can't make changes to the terms without the consent of all the parties, so be sure that everything is in writing. Take a look at the exact terms in the lease. What is the move-in date? What is the move-out date? Will this work for you? Also check carefully whether the landlord has a provision for when you need to tell them if you are renewing for the next lease term. Some leases will have an automatic renewal provision, meaning that unless you tell your landlord in writing that you are not renewing, you automatically renew for the next year. When do you have to give notice that you are moving out? How do you give notice? You should always put any notices to your landlord in writing and make sure you have a copy. For example, you can email your landlord your move-out notice and copy yourself so you have a copy in your email. If your landlord uses an online portal, make sure you take a screenshot of everything before and after you submit. Sometimes you are not able to access your requests and notices after you've put them into the portal. What is the rent amount per month? Is the total amount of rent for the lease term calculated correctly? You can consider negotiating the rental amount. While still unlikely, there is a possibility now that there is more housing stock available that you can negotiate your rent. When is the rent due? Where and how are you supposed to pay the rent? Always be sure you have some way of documenting your rental payment. even if it is just a screenshot before and after you submit your rent in a tenant portal. When do you have to pay the first installment of rent? Is it the first month you'll be living there? Or do you have to pay 1 month's rent ahead of time? You should know these specifics for budgeting purposes and to be sure you don't over or underpay your rent. You must pay your rent on time. The landlord can charge reasonable fees for late rent. Are there late fees listed in your lease? Your landlord may also file an eviction against you if you are late paying rent. If you are having trouble paying rent and are concerned about what will happen, that is a really good reason to schedule an appointment with SLS next year. Living with roommates off campus adds another layer of responsibility to living with roommates on campus. Now there is money involved. And many off-campus leases include a joint and several liability clause. An example of this clause is all tenants and cosigners shall be held jointly and severally liable for all terms and obligations under the lease. In non-legal speak, this means that when signing the lease, you are responsible for not just your portion of the rent. You are actually responsible, both individually and together with your roommates, for the total rental amount, plus any damages caused to the property. Here's an example. You are renting an apartment with 3 other people. The total monthly rental amount is $2,000 per month. You each pay into the tenant portal $500 per month. One of your roommates informs you that he's not coming back for spring semester, and then he just stops paying rent. If you signed a lease with a joint and several liability clause, your landlord may recover that unpaid $500 from your missing roommate, or it can try to recover from you and the remaining roommates. You can be sued by your landlord for that money, either with the rest of your roommates or just on your own. And if your parents co-sign your lease, they may be liable as well. This is another reminder for you to carefully consider whether you should be signing a lease at this point. You may be very sure that you are going to be in Columbus next year, but what about all your roommates? Are you certain they'll be here? If one of your roommates decides not to move in, your options may be pretty limited. You'll either have to try to collect the rent from that roommate, you'll have to pay for their portion, or you'll have to find someone to sublease. None of these situations is ideal and could be avoided if you wait longer to sign your lease. Whatever you decide, you should definitely create a roommate agreement. You can find a sample agreement on our website at studentlegal.osu.edu/offcampus. Talk through the agreement with your roommates before you move in. You'll go over how much each person pays, which utilities are in which student's name, and more. This process is really useful to help you through potential issues with your roommates, so hopefully you can avoid them altogether. Most leases require you to give the landlord a security deposit. The security deposit is basically a promise to your landlord that if there's unpaid rent or damages at the end of the lease term, the landlord can use the security deposit to cover their losses. There are specific laws about security deposits that landlords must follow. In the past, you were almost always required to give the landlord the security deposit at the time you signed the lease. The law has changed in Columbus about security deposits. If the property you rent is within Columbus city limits, the law now requires the landlord to also give you an option to pay your security deposit over 3 or 6 months after your lease starts. If the landlord fails to give you this option, it can be a criminal offense. You can report violations to the Columbus Urban League at fairhousing@cul.org. Please also let your attorney know if you believe your landlord has violated the law, or if you have specific questions about this change to the security deposit law. You also have certain responsibilities in order to get your security deposit back. You must return the property to your landlord in the same condition you received it, ordinary wear and tear accepted. The law provides for a certain amount of insignificant damage to the property, like a smudge on the wall. However, damage beyond that, like dirty carpet with holes in it, is considered more than ordinary wear and tear, and your landlord can deduct the costs from your security deposit. You need to document the condition of the property at move-in so you can prove that you did not cause any damages that are already there. You can find a move-in checklist on our website. Use that and document every little scratch, dent, or stain. You also want to take pictures and video of the property. Keep copies of everything. When you are ready to move out, You're going to clean the place thoroughly. You'll then do a move out checklist found on our website and document the condition with pictures and video. You do this for several reasons. One reason is that if the landlord says they had to replace a big stained carpet in the living room, if it wasn't really stained, you'll have photo evidence of that. You should also consider who you're inviting over to your house. If your guests cause damages to your property during a party, your landlord can charge you for those damages. Your landlord has the duty to repair the property should something not work or need fixed. If you cause the damage to the property, even though your landlord has the duty to repair, you may be liable for the cost of the repair. If something needs to be repaired, you must give your landlord written notice. The written notice is important for several reasons. First, it protects you. If something needs repaired and you gave your landlord notice about it and they don't fix it and further damage is caused, you should not be liable for that additional damages cost. Second, written notice proves you gave the notice. If you just tell your landlord in passing or you call the maintenance line only, there is a lack of proof that notice was given. If you are supposed to call a maintenance line, always follow up your request in writing. Last, you must give written notice to start the clock running on when you can take advantage of the legal remedies available to you if the landlord fails to make repairs. Once you give that written notice under Ohio law, your landlord has a reasonable amount of time to make repairs, not to exceed 30 days. That means if it is not an emergency, your landlord can take up to 30 days to make the repair. If you have an emergency like no heat in winter or no water, the reasonable amount of time to make repairs will be less than 30 days. On our website, we have a sample notice to repair you can give your landlord. Use the form and email it to your landlord. If your landlord has an online portal, take a screenshot of before and after you submit your maintenance request. If you give notice to repair to your landlord and they do not make repairs in a reasonable amount of time, schedule an appointment with Student Legal Services. Note that when your landlord is coming into your property to make repairs or for anything else, unless it is an emergency or you have consented for them to enter, they must give you 24 hours written notice. If your landlord consistently enters your property without this notice, please schedule an appointment with Student Legal Services. In addition to giving your landlord a notice to repair in writing, you may also want to contact City Code Enforcement about your issue. If you are renting within the City of Columbus, we suggest you download Columbus's app. Within this app, you can make service requests, for example, to let the city know that trash was not picked up, schedule a bulk pickup, ask for streetlights to be repaired, and more. The city is updating this app, and as of now, there are a number of off-campus housing issues that are not included that you can report to City Code Enforcement. For example, if you have no water or no heat in colder temps, you should report this immediately to the city for code enforcement to come and inspect the property. Other reasons to contact code include if there are loose wires in the property, there are rodents or other pests, or there's exposed insulation in the attic. You can contact code enforcement to report these by calling 614-645-3111 or email 311@columbus.gov. You can get to that contact information in the Columbus app by choosing Need Help. As a reminder, if you have a repair issue at your off-campus housing property and need help, this is a good reason to schedule an appointment to speak with a Student Legal Services attorney. You may have additional costs other than rent. First, your landlord may require an application fee. The application fee needs to be reasonable. Most application fees are non-refundable, but you should check with your landlord about that. Some landlords request a holding fee from prospective tenants. We don't like holding fees. The landlord will generally ask you for what amounts to 1 month's rent or another large sum in order to quote unquote hold the property for you while you decide whether to sign the lease. They say they won't allow anyone else to sign while you are holding the property. We've found students get burned by these holding fees. If you're going to pay one, you should absolutely get the terms of the fee in writing and have your landlord sign the agreement. You want to know how long you have to decide whether to rent, whether the landlord has any way they can give the property to someone else during that time, and what happens to the holding deposit after you've either signed or you decide not to sign. Does it become the security deposit if you do sign? Does the landlord keep the whole amount if you don't sign? Utilities are another extra cost you'll want to consider. You'll need to think about electric, gas, water, and sewage, internet, and cable. Take a look at your lease. Are any of these mentioned? Does the landlord include these costs in your rent? Do you pay an extra amount per month to the landlord? Or do you have to set up utilities in your own name? If you do have to set up utilities in your own name, don't have one person take all the responsibility. Get the name of the utility provider from your landlord. And then about 1 month before you move in, call the utility company and let them know you'd like to set up an account and switch utilities into your name on your move-in date. We recommend you don't wait until right at move-in to do this because everyone will be calling then. Also, make sure you cover in your roommate agreement how you will pay each other for utilities. In general, your lease terminates at the end of the lease term or move-out date listed in your lease. Most leases in the off-campus area bind you to the entire rental term, which is usually about 11.5 months or 12 equal installments of rent. There are some ways that you can terminate your lease early and not be financially obligated for the remainder of the year. For example, because the condition of the property is uninhabitable. However, those situations are rare and there are specific steps you must take under Ohio law in order to take advantage of those remedies. So it is difficult to terminate your lease before the end of the lease term and not have any financial liability. If you are in a position that you want to terminate your lease early, schedule a Student Legal Services so we can walk through your specific options. If you decide to leave your lease early, you may consider subleasing to another person. Look carefully at your lease. Does your landlord allow subleasing? Under what conditions? A sublease is generally a contract between you and the person you are asking to move in. It is not a contract between the person coming in and the landlord. You still owe duties under the lease to your landlord, like paying the rent on time. You also want to consider what happens to the security deposit if you move out and someone new comes in during the lease term. Also keep in mind that you're in a college town. If you're leaving for the summer and you want someone to sublease your place, it can be difficult because so many students are in the same position. We have a sample sublease agreement on our website, but we highly suggest you speak to a Student Legal Services attorney if you are considering subleasing, so we can review your lease with you and help you strategize for your specific situation. You need renter's insurance. I will say this again so it sinks in. You need renter's insurance. I had no idea what this was when I first rented, so I'm going to explain a little more. Your landlord has insurance on their property, the building itself, the plumbing, the electric, etc. However, your landlord's insurance usually does not cover your things in the event something happens to the property. Let's say your apartment is broken into. It's not anyone's fault, it just happened. They took all your valuables, your jewelry, electronics, your cool shoes. If you do not have renter's insurance, you do not have a way to replace those items. The way renter's insurance works is that you pay a fee, usually around $10 to $20 per month, which is called a premium. Your policy will have a certain dollar amount of coverage, and you can be reimbursed up to that amount for the value of your property. Your policy will also have a deductible amount. If you make a claim, you'll give your insurance company the information about all the things that you lost and their value. If you purchase things of high value, you should keep a receipt. Otherwise, they'll use the typical value of those items. Once you've made your claim, your insurance company will reimburse you that amount minus the deductible on your policy. Your deductible amount is determined when you sign up for your policy. So let's say you have $2,000 worth of property to be reimbursed and your deductible is $150. The insurance company will give you a check for $1,850 for your loss. We suggest you first check with your car insurance provider to see if they offer renter's insurance. You may be able to bundle the policies for a better rate. Some people will suggest that if your parents own a home, they should check with their homeowner's insurance to see if you are covered for living off campus. You definitely should do that. But if your parents' homeowner's deductible is high, it may be worth it to take out a separate renter's insurance policy just for you. Note in the example above, if you only have the homeowner's insurance policy and their deductible is $2,000, you would not get any money from the insurance company for your losses. When you move out of the property, in order to return possession to the landlord, you need to return the keys. Check your lease to see if there are directions for doing so. If not, contact your landlord close to move out if they have not given you instructions. You should also give your landlord written notice of your forwarding address. Without this information, your landlord cannot get your security deposit to you. You can find a sample written notice of forwarding address on our website. Your landlord has 30 days after your lease term ends to return your security deposit in full, or to send you an itemized list of damages if they only return a portion or none of your security deposit. If you do not receive your deposit, you should send your landlord a notice of wrongfully withheld security deposit, also found on our website. If you received only a portion of your deposit and you disagree with the landlord's assessment, schedule an appointment with Student Legal Services if you're still eligible. You'll hear your lawyers, that's us, say this a lot, but please, please, please document everything. That means when you pay your rent, get a receipt, take a screenshot, or have other proof. When you send a notice, keep a copy of that correspondence. Be sure to date it. We recommend that students create an email folder with all of your off-campus housing related information. The more documentation you have, the better chance you have in getting any issues with your landlord resolved. We are here for you, and there are a lot of other resources available to you at the university. One of the most important is Off-Campus and Commuter Student Services, which is a department within the Office of Student Life. Off-Campus has a number of resources available online to help as you navigate finding housing, moving, and living off campus. If you're looking for roommates, they have an online roommate search and roommate fairs. They also provide free safety devices, including window alarms. Off-campus also houses the Community Ambassador programs. Community ambassadors are students living in the university district who help you remain connected to the university as you are living off campus. They send out newsletters, host events, and are a great resource to you. Congrats, you now have a good start for your move off campus. Now you need to schedule your lease review appointment if you haven't already, so you can talk to a Student Legal Services attorney about your specific lease provisions and ask any questions. These appointments will be conducted by phone, and you will receive a confirmation email with information about your phone appointment. If you would like your parents to join on the call, please make sure to note that when you make your appointment. And remember, after you schedule, send a copy of your lease to studentlegal@osu.edu. We can't review a lease without the lease.